In a major new decision, the Supreme Court of the United States has reshaped how one of America's most important civil rights laws works, the Voting Rights Act of 1965. Some say this decision strengthens the Constitution. Others say it weakens voting protections. So what actually changed? Let's break it down clearly, step by step. The Voting Rights Act was passed in 1965 to stop racial discrimination in voting. Before that, especially in southern states, black voters faced serious barriers. Literacy tests were used to block registration. Poll taxes made voting financially difficult, and district lines were often drawn to reduce the influence of minority voters. To address this, the law introduced major protections. One key provision was Section 5, known as pre-clearance. Certain states had to get federal approval before making any changes to their voting laws. This was meant to prevent discrimination before it happened. However, this provision was largely removed by the Supreme Court in Shelby County versus Holder. Another key provision, Section 2, is still active today. It allows lawsuits against voting systems or district maps that result in discrimination, even if there is no clear proof of intent. This results-based test became the main tool used to challenge unfair districting. The recent case focused on how electoral districts are drawn. In states like Louisiana, lawmakers created maps that included majority-minority districts. These were designed to comply with the Voting Rights Act and ensure minority voters had a fair chance to elect representatives. But challengers argued that the state relied too heavily on race when drawing those districts. They claimed this violated the Constitution's Equal Protection Clause. So the key question became, can states use race to fix discrimination without violating the Constitution? The Supreme Court ruled that race cannot be the dominant factor in drawing districts unless it meets strict constitutional limits. This means that even maps designed to comply with the Voting Rights Act can still be considered unconstitutional if race plays too large a role. The decision raises the legal standard. It is now harder for states to justify race-based districting, and courts may require stronger evidence beyond just unequal outcomes. Previously, courts focused on whether minority voters had less opportunity to elect their preferred candidates. Now, there is more emphasis on constitutional limits and less reliance on outcomes alone. Courts are more cautious about allowing race to guide districting decisions. This creates a tension between two goals, preventing discrimination and avoiding race-based government action. In terms of elections, the impact could be significant. In the short term, it becomes harder to challenge district maps under the Voting Rights Act. States may have more flexibility in drawing their districts. In the long term, this could lead to changes in political representation, especially in closely contested areas. One of the most discussed questions is how many seats could be affected. Analysts estimate that roughly 5 to 15 congressional districts nationwide could be impacted. Many of these districts are in southern states, such as Louisiana, Georgia, Alabama, and Texas. These districts were often designed to increase minority representation and, in many cases, lean toward Democratic candidates. As a result, some of these seats could shift toward Republicans, particularly in competitive elections. However, not all districts will change. Legal challenges, local laws, and political factors will all play a role in determining the final outcome. Can states change their maps before the 2026 election? The answer is yes, but with limits. States may redraw districts depending on their legal timelines, and this decision gives them more flexibility. However, changes can still be challenged in court, and last-minute adjustments may be blocked depending on the situation. So while changes are possible before 2026, they are not guaranteed. Political reactions to the decision are divided. Many Republicans argue that the ruling reinforces a color-blind interpretation of the Constitution. They believe it prevents the government from making decisions based primarily on race. Many Democrats argue that the ruling weakens protections against discrimination. They believe it makes it harder for minority communities to secure fair representation and continues a trend that began with earlier decisions like Shelby County versus Holder. There are both advantages and disadvantages to this ruling. On one hand, it reinforces the idea of equal treatment under the law and limits the role of race in government decisions. It may also create clearer legal standards for courts to follow. On the other hand, it makes discrimination harder to prove and could reduce minority representation in some areas. It also weakens a key tool that has been used for decades to enforce voting rights. So, did the Supreme Court declare the Voting Rights Act unconstitutional? No. But it did change how the law is applied, especially when it comes to drawing electoral districts. The full impact will likely appear in upcoming elections, including 2026. Thanks for watching.